Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us learn about the relationship between municipal law and the international law and the theories regarding explaining the relationship between them. Relation between international law and municipal law apparently seems that there is no relationship. But if examined with philosophical eye, then it would seem that there is a relationship between both the legal orders. A test to observe the relationship between these two systems may be conducted in case of a conflict between the two legal systems, municipal law and the international law. So, the relationship between this municipal law and the international law are explained by some of the theories. The first is the dualistic theory. The dualists emphasize the difference between national and international law and require the translation. Without this translation, international law does not exist as law. International law has to be national as well as, or it is not a law at all. If a state accepts a treaty but doesn't adapt its national law in order to conform to the treaty, or it does not create a national law explicitly incorporating the treaty, then it violates the international law. But one cannot claim that the treaty has to become a part of national law. Citizens cannot rely on it and judges cannot apply it. National laws that contradict it remains in force. So according to dualists, national judges never apply international law. Only international law that has been translated into national law will be applied. According to the dualistic view, the systems of international law and municipal law are separate and self-contained to the extent to which rules of one are not expressly or tacitly received into another system. So in the first place, they differ as regard to the sources. The sources of municipal law are customs grown up within the boundaries of the state concerned and statutes enacted therein, while the sources of international law are customs grown up within the family of nations and law-making treaties concluded by its members. So in the second place, municipal law regulate relations between the individuals under the sway of a state or between the individuals of the state, while international law regulates relations between the member states of the family of nations. Municipal law is the law of the sovereign over individuals, while international law is the law between the sovereign states. So here the dualistic view is that every international law has to be translated into a national law and the people of that nation shall adopt it. Then only a treaty is valid, otherwise it is not valid according to the dualists. Coming to monistic theory. Monists assume that the internal and international legal system form a unity. Both national legal rules and international legal rules are of a state has accepted. If, for example, by way of treaty, they determine the actions are legal or illegal. In most monist states, a distinction between international law in the form of treaties and other international law like jus cogens is made. International law doesn't need to be translated into national law. In the purest form, monism dictates that national law that contradicts international law is null and void, even if it predates international law and even if there is in the constitution. It maintains that the subject of the two systems of the law are essentially one, and the international law regulates the conduct of the states while the municipal law of the individuals. So monistic theory says that there is no difference between international law and the municipal law. They both are the parts of the same law, and if there is any contradiction between the international law and the municipal law, then the international law will prevail over the municipal law. The next is the transformation theory. According to this, the treaty need to be transformed into the national legislations according to the national legislations, and there are certain drawbacks. According to this theory, they says that international law and municipal law has two distinct systems is incorrect, and international law binds states only, whereas municipal law to individuals is incorrect, because international law is the sum of the rules which have been accepted by the civilized states in determining the conduct towards each other. And they also said that the transformation of treaties into national law for the enforcement, this is also not true in all cases, because practice of transforming treaties into national is not uniform in all the countries and doesn't follow any certainty. So this is transformation theory. And the next is delegation theory. According to this, every state has a right to decide for itself whether the provisions of the treaty has to come into effect or not, and they have to be incorporated into the municipal law or not. And there is no need for the transformation of a treaty into national law, but because it is an extension of the same act. The delegation theory is incomplete, for it does not satisfactorily meet the main argument of transformation theory, and it also assumes that the international legal order fails to explain the relations existing between the municipal and the international laws.